And Dr. Liu, welcome to Dr. Moore. I'm turning this over to you.
Okay, welcome everybody. Thanks for being here. I'm going to try to pull up the PowerPoint. Share and let me. There we go. Okay, well, for those of you who don't know me, I'm Dr. Ruth Outz Moore, and I am a full-time faculty member here at the Chicago School of Professional Psychology. And my area of specialty is counseling children and adolescents, particularly those who've experienced abuse and trauma. So when I started doing work with abused and traumatized children, I started getting called to court more frequently. I also do a lot of work with high conflict divorce. And so when you work with children and you work with divorce and you work with abuse and trauma, you inevitably get called to court. And what I found was that as a counselor, I didn't have really any training in knowing how to navigate the court system and how to deliver confident and competent testimony, which prompted me and another colleague to start really doing a lot of research in that area and a lot of training of counselors nationally about courtroom dynamics. So the title of this workshop is I've Got to Testify, Becoming a Competent and Confident Counselor and Working with Clients with Court Involvement. So if you haven't watched, or if you weren't here for part one, or if you haven't viewed the recording from part one, I recommend that you do that. Even if you're here and you haven't seen part one, that's okay. But part one is going to give you a little more of the foundation around knowing how to respond to a subpoena and those types of things. So in part one, we basically talked about the different roles of counselors in court. So I may touch on some of these things as we go along the way, but I'm not going to go into a lot of depth with that. But I might reference back to that. So just know that these sessions are recorded. So even if you're here today and you think, now wait, what was that? You can always go back and access the recording from part one. We also talked about multidisciplinary collaboration, the members of that team, the court professionals that might be involved. We talked about legal and ethical issues. We talked about how to respond to a subpoena, and we briefly touched on documentation and court reports. And so we're going to hit on that more today. So today our learning objectives for this part, for part two, is we're going to look at the differences between a fact witness and an expert witness. We're going to discuss how a counselor's testimony will differ when they're a fact witness versus when they're an expert witness. We'll look at the difference between testifying in court versus testifying and giving testimony in a deposition, because those do look differently. And we're going to talk about some of the attorney traps that counselors may encounter when testifying in court. That's probably my favorite part of the workshop. So as I was going back and reviewing the program description that I gave to Dr. Rush Wilson, I thought, wow, I said I was going to do a lot of things in an hour, and I only have an hour. One of the things that I said in the description that I was going to do is delve deeper into legal and ethical issues. And then I thought, I don't have a lot of time to do all of that. So what I want, part of what we talked about in the last workshop in part one was knowing the mandated reporter laws in your state, documenting that, and how mishandling a case can increase your likelihood of a malpractice suit or getting an ethical violation against you. So you want to be cautious with that. Also, legal issues, their duty to warn, be familiar with those things in your state, duty to protect, age of consent for treatment. We talked about last time that some states, if you're 16, you can consent to your own treatment. In some states, it's 18. Age of consent for sexual activity, because when we talk about being a mandated reporter, that if the legal age for sexual consent is 16, and it's a 15-year-old that had what they call consensual sex with someone, that it still warrants being reported. So you want to know all of those things. And be familiar with your state. And we talked about the ACA ethical codes last time: the client welfare, informed consent, clients that are being served by others, and that's where we get into that multidisciplinary team, avoiding harm and avoiding imposing values and working with multiple clients. So I'm not going to go back into reviewing all of those codes since we did that last time, but we also talked about confidentiality and privacy, respecting clients' rights, exceptions to those rules, information shared by others, the dynamics of couples and family counseling and how that plays out in terms of ethical obligations, clients lacking capacity to give consent, and records and documentation. We also looked at consultations on ethical obligations and reporting to third parties. So again, this is our time. So in this workshop, I said we'd delve deeper into that. So I tried to think about how can we delve deeper in the amount of time that we have to still hit what I think is really some of the most important parts. Not obviously ethical components or legal and ethical components are important. So what I want you to do is kind of use your critical thinking skills as I'm going through the slides and we're discussing things today about courtroom dynamics, and think about when you think about the codes that we talked about last time. As we're going through this, what legal and ethical issues might arise when considering these issues as we move forward in this presentation. So really kind of start to try to gel all of this information together of, wow, okay, how might it play out if I don't know the age of consent for sexual activity in my state? How might this play out if I'm called to court to give testimony? How might this come back and create a potential ethical dilemma for me if I was working with a couple in counseling and then started counseling one of the members of the couple outside of that? How might that come back? So kind of think of those things as we're going through the presentation. And then at the end of this presentation, what questions do you think about the questions that you have? You know, if you want to jot them down as we go through, based on these potential legal and ethical dilemmas, because we will have some time for question and answer at the end. So we're first going to talk about the courts of involvement. So it's really important to know your court. I don't ever want to walk into a court and not know what court I'm going to or what this court handles and those types of things. So if you're working in the state of Tennessee, Mississippi, and Delaware, they have what we call chancery court. So I've practiced in Mississippi and Tennessee. And so chancery court is where divorces are handled. So if it's a custody matter, those types of things, family law type of stuff related to divorce, that goes to chancery court. Other states don't have chancery court. So they use the district court or the circuit court for matters of family issues such as divorce, juvenile, and domestic matters. Now, why is that important? As I said, I always want to know what court I'm going to be testifying in, what that court handles. I also want to know who my judges are, because you've got judges who've been on the bench for many, 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 many years. Some judges are more conservative than others in working with high conflict divorce. Some judges are more pro-father, some are pro-mother. I just like to know and to be really prepared when I go into a case. In Mississippi, there's a judge, and when I gave a presentation last week with a colleague, we both practiced in Mississippi, and there's a judge that's been on the bench forever, and he hates counselors. I mean, he says that, I hate counselors. He said it to me when I was on the stand. I don't like counselors. And I said, well, I'm really sorry to hear that. He had it turns out it's his own personal stuff, but his son, there were allegations of abuse towards his son when he was going through a divorce. And there was a counselor who testified basically in favor of supporting what the child had disclosed, and he doesn't like counselors. So I know going into that court, I know his reputation. I know he doesn't like counselors. I know the judge was very hard on me. The attorney didn't even have to ask questions because the judge was interrupting and interjecting, and he was asking me questions, which was really not appropriate. But I know when going to that courtroom to be prepared and to keep my composure and those types of things, and we'll talk more about that. So that's why I want to know what court that I'm going into. And the more you know, the more professional you seem, the more knowledgeable you seem, and that's going to help your testimony be more credible. So in these courts, in whether you're talking chancery or district or circuit, where they're handling the divorce cases and things like that, it's the court that rules on equity, which is basically what is fair, not just on the law, that they look at, so like an example, I was working with two children, young children, aged 3 and 5, where there were allegations of sexual abuse towards the father, and very graphic allegations. And the 5-year-old had started perpetrating the 3-year-old. And so the mother, they had just gotten divorced. And so the mother said, I'm not going to send the children for visitation because they've made these disclosures. Now, one side is trying to say, oh, well, she's coaching them. But the reality was that he had greater access to the children now that he was no longer living in the home. And when they were going on the weekends, he was abusing them. And when I went into court to testify about what the children had disclosed and what I was seeing in play therapy with them, the judge said, I'm not here to decide if this man is guilty or innocent, because that's criminal court, right? He's like, I'm not here to decide that. He said, I'm here to decide whether or not this father gets visitation with his children. And I believe that all fathers get visitation with their children. So before I hear any testimony from Dr. Ruth, I am going to grant visitation. So they ended up hearing my testimony, and they did do supervised visits at first in a period of time with no contact so that they could work in therapy. And then, they gradually went to supervised visitation. But that's an example that it was really more about he was going to do what he felt like was fair in his court. And the judges make decisions regarding what's equitable. Now, youth court is where youth court programs are there to determine what's fair and restorative sentence for the youth respondent. So with youth court, this might be where you have truancy. This might be somebody that, whether it's an adolescent that's engaged in theft or violent activity, gang activity. It could be any number of things why a person might go to youth court. But also you might see someone come to youth court if the child has been removed from the home and the parents have to come to court to try to see if they can get the child back, that is handled a lot of times in youth court. Criminal court is your testimony is concerning the child and possible disclosures, but you could be testifying to information that a parent has shared with you. It can be, I had a client that it was an adult male client that had shaken his baby to the point where like 3/4 of the baby's brain, and they used the word was mush. And so was paralyzed on one side, and it was court ordered to come to therapy, but I had to go to criminal court and testify about findings and things like that. So criminal court, just be prepared, to that whatever your role in that case is, that they can ask you questions in all those different areas. So even if you're working with a child, they can ask you about contact with parents. So the reason I include these slides about knowing your court is it's a different, each court is a different stage. And I hate to say it that way, but that kind of is the way it is. So in divorce court, whether you're talking circuit or district or chancery, the literature will even tell you this, that a lot of times you see attorneys at their worst behavior because they really want to win. That's what they can be really nasty, not to scare you, but we're going to talk about how to handle that. They can be really nasty. They can really try to trip you up, try to get you to say something that makes you look like you don't have knowledge, or they might try to get you slip up to make you seem as though you've done something unethical. That's chancery court or divorce court. Youth court is a little more laid back to me in the sense that it's really just a judge trying to make the best decision in terms of a juvenile or of a family. Criminal court is, I hate to say probably one of my favorites, but what I like about criminal court is the attorneys are on really good behavior because they want the jury to like them. And so if they're mean to a witness, then the jury's not going to like them, and then they're not going to win their case. And so it's a little bit, to me, less intimidating in some ways in criminal court than it is in divorce court. So let's talk about types of witnesses. There are fact witnesses, there are expert witnesses, and there are also expert witnesses that are court appointed. So the fact witness relays information, not opinions about the case. So as a therapist, it's best to be called as a fact witness, because this is going to help you maintain that therapeutic role. And we talked about that last time around, how cases with court involvement the relationship can become contaminated because so much information is getting shared with other people that, whether it's the child or the parent, whomever you're working with, can start to feel lose that sense of safety because so many people are involved and information is being shared. So a fact witness is really just going to answer questions about the case. How many times did they come to therapy? If it's a child, who brought the child to therapy, who paid for the sessions. It's just basically, you can tell you can share what the child disclosed, but you're only giving the facts. The child disclosed blank, or the parent's goals were working on blank. So you're just giving information. So you're not interpreting, you're not giving recommendations, you're just giving information. Now, an expert witness, they testify for specific reasons on certain matters. In some cases, they're not considered to have a standing in the case. So if you remember last time, I think I mentioned a case where I was brought in more to educate the court on, it was actually a case where in Mississippi in the early 90s, mid 90s, where the husband and wife were divorcing, and the husband was alienating the children from the mother and not allowing the children to visit. He was angry because the mother was in they divorced and she was in a same-sex relationship. Now, this is rural Mississippi in the mid 90s. So you got to understand, I'm from Mississippi, so I can talk about Mississippi, right? Mississippi is still, very, very behind in terms of views on things and all of that. So the father was trying to say that the mother was unfit because she was in the same-sex relationship. And so the judge said, well, I don't know much about homosexuality. And I'm like, evidently you don't, right? But so he said, I want the attorneys to find somebody that can come in and educate me, in the court about what the literature says about same-sex parents, which was ridiculous, but I appreciate the fact that he at least did that. So they contacted me and asked me to just present literature to the court around around same-sex parenting. So that was a case where I didn't have a standing in the case. I was just there to give that information. Now, there are times where you can be called in as an expert witness and where, let's say you're working with a child, and they bring you in and they want to bring you in as the expert witness. And this is where it gets a little sticky, because a fact witness can only testify to facts, but no opinions. An expert witness has the credentials and experience to be able to offer those opinions. Now, just because you have that experience and credentials doesn't mean that you should. And we talked about that in the first part of this series last time, is that if my role was not the forensic interviewer, then I don't need to be operating or giving testimony in role as a forensic interviewer. If I wasn't the custody evaluator, I'm not going to testify or give those interpretations. Now, this is where it gets challenging, because in some states or in some courts, that they give the same consideration to treating professionals, so that they might say, hey, you qualify as an expert. And I'm thinking, no, I'm not here to give the facts. And then that's where they start to get you to try to give interpretations or to give recommendations. And so that's kind of a slippery slope. So if I'm appointed by the court, or if I am subpoenaed to court, I clarify on the front end, what role am I serving? Am I a fact witness or am I an expert witness? So for you all as students who are new in this profession, because what I see happening a lot of times with whether it's interns or new professionals is that they get subpoenaed to court, and they're like, I don't have any experience. I can't go to court. I don't have any, that they're not unlikely to get qualified as an expert. So in some states, they may not want you. You still have to go. They may say, she's just not qualified as an expert. We don't want her here. We don't want to hear what she has to say because she's not an expert. But there might be some attorneys that say, hey, look, even though she's not an expert, we want her as a fact witness. So once you've been qualified as an expert, though, in a particular court, you're an expert. It was funny because in Mississippi, I was working on a case. I was in court on a case in 1 week, and the attorney in that particular case, the attorney liked me because she liked what I had to say. So she was the one who qualified me as an expert. A couple of weeks later, I'm there in court on a different case, and she doesn't like me in that case because she doesn't like what I have to say. So she was trying to get me thrown out as an expert. And the judge sat there and shook his head and said, wait a second, you were just here a few weeks ago and you qualified her. No, stop it. She's an expert. Let's move on. But it's once you're an expert, you're supposed to be an expert, but they will ask you that if you've, ever been qualified as an expert, or if you've ever been dismissed because you weren't an expert. So just be aware of that. But I would say, especially as you're new in your career, keep your role as a fact witness. That way you don't fall into that slippery slope of being asked to give a recommendation when you shouldn't, or asked to interpret something when you shouldn't do that. I'm very cautious with the language that I use, even if I'm qualified as an expert and they ask me something that maybe is a little bit outside of my role, I still clarify what my role was. And I can say, generally speaking, or the literature says this, that would be, let's say, like with a, generally speaking, the literature suggests that children who've been sexually abused experience X, Y, and Z symptoms. So I keep it, I'm not going to give that interpretation per se in this case, but I can give generalizations. So a court-appointed expert witness would be one, like I mentioned earlier, with the case in Mississippi. Also, I've been called before to just educate the court on the dynamics of parental alienation. But if you're a court-appointed expert witness, then you have to advise the people involved of what your findings are. You could be deposed by any party, and you'll be called to testify, or could be called to testify by the court by any party. And you can be cross-examined by anyone. So basically, if you're court-appointed, most likely you will be back to testify in court, and just know that anybody can ask you questions. And there is really no such thing as confidentiality in those cases because it's already involved. It still doesn't mean that you don't discuss that with your client, that even though, but you do need to let them know the limits of that confidentiality because you're court appointed and that information will be shared with the court. So we're going to talk a little bit about tips for documenting and report writing. And I know we touched on some of this last time. So you always want to, first of all, document every session that you have, and do that in a timely manner. That, sometimes we forget things, we forget the details. It's best to do those session notes immediately after with your client, or if you're write notes, and if you're doing them later in the day or in your lunch hour, that's fine. But jot those notes down so that they're at least fresh on your mind, because that's going to be really important. Document all contact with any of the parties involved in the case. And I think I talked about this last time, but I know for me when I was in private practice, particularly full-time, you're seeing clients back to back to back to back to back. And then all of a sudden you get like a little bit of a break and you've got like 4 phone calls to return, and the guardian ad litem has called you. And so you pick up the phone, you chat for, 10, 15 minutes about the case, and then you move on to your next client. It's really easy to forget to write that down. But that contact is so important. And know that when you're working with other professionals, they're writing down what was discussed, and you don't want to show up in court and them say, did you have a conversation on August 14th with so-and-so? And you're like, did I? You need to have that information. and be clear on that. Because what I have seen happen is that an attorney might say, you had a conversation on this date with the guardian ad litem and you said this. And then I'm very clear, no, I had a conversation on this date at this time, and this is what was discussed. But if you don't have that record there, that documentation, then they're going to be in the right. And things can get easily misconstrued when you have conversations with other professionals. Keep accurate records, especially when there are disclosures of abuse. I see this happen. I get questions about this a lot, of what you document in your note and what you don't. When I'm working with abuse allegations, I document the disclosures verbatim. And so if I have a session with a child that's given a disclosure of abuse, when that session is over, I immediately do the note so that I can remember those verbalizations exactly as they were told and have that there. If I'm working with kids or anybody really, the record is for me in terms and for me to know what we're working on, what was, what the most important highlights were of the session. I don't necessarily write every single detail of every little thing that was discussed. I talk more about the dynamics, but if it is something where there are allegations of abuse or something, let's say it's a high conflict divorce and this child is making, negative statements about the other parent, I want to be sure that those statements are in the record, because that when I give that information in testimony, if it's not in the record, it can be perceived as that I'm just making this up. So it's like, no, it's documented that this is what was said in the session. And you want to use bias-free language. I remember working at a mental health agency, and it was one of my first jobs. And I remember reading a note that the case manager had written, and she was talking about having gone to do a home visit and that the home was not clean, and that the client, the client's hygiene was poor. But what she wrote was, this was the nastiest, most disgusting house that I've ever been to, and he smelled really bad of body odor. And I thought, okay, so you can't say that. You can say, that his appearance seemed disheveled and unkempt. You can say that the house, you can say what you saw, the windows were broken, or there were dirty dishes on the table. The house, there seemed to be a foul odor. You can say those things, but you want to think about the record of what if the client read this? How would the client feel? So you want to just use bias-free language and be sensitive to that. I mentioned using seems and appears. The client seemed angry as he talked about having to visit with his father. He appeared frightened when his mother walked into the room, those types of things. But I'm not going to say he is scared of his mother or he doesn't like his father. I can say the client stated that he doesn't like his father, but I'm not going to say he doesn't and make those definitive statements, because I can't really speak for the child. I can say what the child or the client has said. You're going to mention who, and we're talking about court reports here. So in your notes, you'll do the same seems and appears, but court reports especially as well. If you're writing a report to the court, we talked about that last time, that sometimes if they subpoena your records, sometimes they will prefer a court report instead, because they don't have to go through and read all of the notes. They just really want to know where you're coming from and what sort of the nature of your testimony is going to be. But if you're giving information about the case, you need to talk about where you obtain the information. One of the biggest things that I get heat about in court cases, especially when working with abuse or divorce with children, is that if I'm writing a report and all of the information that I'm giving about the child is from one parent, it does make me seem as though I'm biased. But if I have tried to reach out to include the other parent and they don't respond, then I can say was unable to meet with the other parent. So I can at least say that I attempted. The other thing is, there are times where if there are allegations of abuse, if there's an ongoing investigation, I may not interact with the alleged perpetrator if it's a parent. or especially if it wasn't a parent, but if it was a parent, I may not, for the safety of the child. But I'm going to include the information, was presented to me by the child's mother or by the child's father or whomever, but I'm not going to, but I'm going to include. So, because they will come back and say, so this is all the information you got from the mother, correct? Yes, that's correct. So you didn't get any information from the father. It's like, no, I was not able to interview him, or because there's an ongoing investigation, he was not, Family and Children's Services felt like for the child's protection at this time, he should not be a part of that. So just mention who you were able to interview and who you weren't. You're going to avoid definitive statements and generalizations. And I talked about that a little bit earlier and also in the last workshop. So you're never going to say definitively that a child has been sexually abused, even if the child disclosed allegations of sexual abuse that you felt were credible. You're not going to say that the child's been sexually abused. You can say that the child disclosed X, Y, and Z, or that the child disclosed that he was abused by this person, or the medical findings appear to show that or support that the child was abused, but you can't say definitively. Now I can say, so, and attorneys like that sometimes, especially they'll say, well, so then you can't definitively say that he was abused. No, I can't. I wasn't there. What I can tell you is that he gave a disclosure of X, Y, and Z. The disclosure seemed credible based on what the literature says about looking at the credibility of children's disclosures. I can tell you that he has named no other perpetrators. That's what I can say to that. But you can't definitively say that he's been abused. It's like, no, I can't. I wasn't there. But I can, again, in my experience, tell you that this appeared to be a credible disclosure. Recommendations, if you are giving recommendations, and that's if you're an expert, and again, goes back to the rule in the case, you want to be careful on how you say that, because if Mr. Jones has never been my client and I'm working with Mr. Jones's child, I may firmly believe that Mr. Jones needs counseling or Mr. Jones needs an evaluation, but I'm not going to say that, because I don't want that to come back and say, oh, you gave a recommendation about Mr. Jones and you've never met with Mr. Jones, or you've never been Mr. Jones's therapist. So I might say the court may want to consider whether a referral for Mr. Jones for counseling is necessary based on what the child has disclosed. So you see the difference. It's really just how you articulate those points, but just being very cautious. And again, your recommendations should be based on your role. And you want to include supporting literature when needed, but there's some risks about that. So we'll talk about that. So a lot of times I will include supporting literature. Research shows that children who experience abuse might have these types of symptoms, and I'll include supporting literature. Sometimes it's helpful in court reports because it's not just what I'm saying, that, oh, I think this has happened. It's me saying, no, this is what the literature says. The bad part about that is that you can't know every single piece of literature that exists out there on a topic. You can't, unless you're some Superwoman or Superman or mastermind, you don't know. And so a lot of times they can use that. So you cited you cited this study by so-and-so. Are you familiar with the study by so-and-so? And then if you're not, so you're not familiar with that research, but you're familiar with this research. And so that can be problematic. A lot of times if I'm going to cite something, it's going to be like, someone who's done seminal work where they're a key figure in the field, like Barbara Jo Fiedler in parental alienation, high conflict divorce cases, some names that that way it's a lot harder to kind of trip me up in that area, as opposed to just citing some author that is not recognized in the field. Does that make sense? So best practices for staying out of court. So staying out of court starts before you meet with the client. So always remember that. What can I do on the front end to keep me out of court? And that's going to be your informed consent document. That's going to be making sure the clients understand their rights. Having a disclosure statement in your informed consent about court and your procedures and your fees and all of those types of things. If I know a case has court involvement, I really, really, really do everything in my power to be meticulous with my documentation, to be, just meticulous with all of those things. I mean, I do that with all clients, but with court cases, I really think along the way, okay, how could this come back to bite me? How can this come back to haunt me? So just kind of think about those things in advance. So also communication with the multidisciplinary team can result in conflict resolution without court involvement. That's important to remember, that if you're working, let's say, on a high conflict divorce case, and you've got a guardian ad litem, and you've got these attorneys, and you've got this, that sometimes communicating as a team of like, let's really work together to see what's in the best interest of this family, that it might be that you don't have to go to court to duke it out. And that can depend on the attorneys. I've got some attorneys that I've worked with that are really, really great, that really just want to, like, let's figure out how to make this right for this child. Let's figure out how to, do what we can with these arguing parents, but try to come together for the betterment of the child. You've got some that are all about winning, and they're going to fight, and almost encourage that hostility between the parents. So if possible, see if you can come up with some type of resolution without court. When court seems inevitable, though, explain to the attorney and the client the limits of your testimony. And that's been one of the biggest things, and I mentioned this last time, I think, but is when I say this is what I'm going to testify to, they then decide whether or not they need me. I had a case where the child disclosed allegations of sexual abuse to the mother, and the mother took her to a treatment facility, and the mother was desperate for this child to disclose in the play therapy session, and she did not. So the mother went home, and in an act of desperation, she got a video camera and followed the child around from 7 in the morning until 11 in the evening. You could see on the timestamp questioning her about what her father did to her. And like, you've got to tell him, following her around. So she brought the video in, because the child did tell the mom on the video, and she brought the video into the center. And the center was so concerned about the mother's behavior that they reported the mother to Child Protective Services. And so the mother's upset. Mother brings the child to see me in therapy. The child does make a disclosure to me over time, but it's the exact disclosure that the mother was on video saying to her, did he do this? Did he do this? Did he do this? So at that point, it wasn't going to be considered a credible disclosure, because all of the action that the mom had done. So when it came time to go to court, she said to me, she's like, we need you to go to court. We need you to be our smoking gun. You're going to be our smoking gun. You're going to go in and you're going to say that she's been abused, and that she told you she's been abused. And I said, okay, let me just tell you. And I had a conversation with the attorney as well. And I said, y'all are going to ask me what the child disclosed in therapy, and I'm going to tell you what the child disclosed in therapy. And I said, but I also need you to know that the other side is going to ask me, isn't it possible that the behavior problems this child is exhibiting is not because of abuse, but because of the conflict that exists between the parents? And I'm going to have to say, yes, that is a possibility. And they're going to ask me if I've seen the video, and I'm going to say yes. And they're going to say, do you find that video concerning, or would that video warrant concern? And I'm going to have to say, yes, it does warrant concern. And is it possible that this mother has coached this child? And I'm going to have to say, yes, that's a possibility. She said, but I didn't. And I didn't. I said, I'm not saying that you did, but they're going to, is it possible? And I'm going to say, yes, that is possible. So you decide, y'all decide, this is how this is likely to go down. They decided they didn't need me because they felt like my testimony might hurt them more than it would help them, because my giving the disclosure that the child made, she already made that disclosure on the video, and that contaminated that whole process. Okay, so court testimony and attorney traps. when you have to go to court, you're going to walk into that courtroom, they're going to call you to the stand, they're going to swear you in. And one of the first things they'll usually ask you is to state your name and to state your credentials. Or they might even say state your education and your credentials, or give it to you in different order. So you're going to do that clearly, and you're going to do that confidently. Because a lot of times people say, oh, I just graduated with my master's and I'm working towards licensure. It's like, oh, I just graduated from the Chicago School of Professional Psychology with a master's degree in clinical mental health counseling. And I am under supervision with so-and-so working on my LPC, licensed professional counseling credential. You see the difference? It's like, so it doesn't mean they won't come back at you, but at least you're saying it clearly and confidently. Take time to think before answering questions. One of the things that I find with attorneys is they come at question. And you have to, it is okay to pause. It kind of drives them crazy sometimes, and I kind of like that, but to pause and stop and think. And I do that because I'm like, how can I say this? Because I know how they're likely to come back at me and what question is going to follow. So how can I say this before, so just take that time to think about it. You're going to use a clear, audible voice. You're going to avoid professional jargon. Just use ordinary language. You want to be genuine, and just, if you go in and use a lot of jargon, it just doesn't make you look genuine. Just go in and be yourself. Limit your testimony to role as the witness. We've talked about that. But role in the case, limit your testimony, but also role as a witness. So if you know that you're a fact witness, you're going to be giving testimony as a fact witness. So you're going to be familiar with the specifics of the case. This is one of the most, I saw this done quite a bit in court cases. Hey, sweetie, mommy's in a meeting. Okay, go back. I'll be down there in just a second. Okay, so I've seen this quite a bit, is that they'll ask you lots of questions about the case. How many times have you seen the client? How many times did they cancel? How many times did they no-show? Who accompanied the child or the person to the sessions if it's a child? So they'll fire these questions at you quickly. So when you're doing your court preparation, just know that they're going to ask you that. I've seen this child. I started seeing the child in November of 2015, and I saw the child until July of 2019. I've seen the child, 46 times. You'd have all of that information present or together. The other thing is that they, when you're working with children, that a lot of times they are trying to do that compare, who brought them more, who brought them to this session. So just make sure that you know who brought them, how many times they cancel, keep up with all of that information. Be familiar with your practice and expertise. This is where I have gotten really tripped up before. So now I know when I'm doing my court preparation to be familiar with all of these things. How long have you been in practice? That you would think someone would know that, but you sort of have to stop and think, how long have I been in practice? Has it been? But I'm going to know the answer to that question. I've been in practice for X number of years. How many times have you testified in court? Now that was hard because I wasn't prepared. When the first few times that I asked this, I wasn't prepared for these questions because I thought, my gosh, I don't know. I mean, I know, but it would take me a little while to think about how many times I've testified in court. And obviously now it would take me a really long time because I've done it so much, but you can pause and think about that, but it's just better to know that on the front end. I've testified in, at least X number of cases. If you don't have the exact number, were you declared as an expert, know that. They started, in several cases, I started getting into percentages, and that's where I was feeling like my heart beat a little fast because I start thinking like percentages, and then I'm having to do math inside my head while I'm on the stand. What percentage of your clients are children? What percentage of your clients are abused? They would say like, well, and what percentage of your clients are children? And of that percentage, what percentage of that is this? And what percentage of those cases? And so I'm like throwing out numbers that I'm like, I don't even know if this is accurate. So I think part of what they're doing is wanting you to in cases where I've worked with abuse, that they're wanting to know what percentage of your practice is children, so that you can show, I work exclusively with children, or it's about 50-50 or whatever. How many of the children what percentage have been abused? Because if you say 75% of my cases are abuse, they're going to try to attack it from that way. Or, if you say 2%, I've had them ask me, what percentage of cases of the children that I've seen who've disclosed abuse, what percentage of those have been unfounded? And I mean, those are hard questions to ask. So just be prepared to really think about the case and those dynamics and your involvement with that. Again, testify only within your role. Don't make recommendations that are outside your role. We've talked about that. It is often the attorney's attempt to make the counselor appear unethical. So if they can make you look bad, they might want to. Sometimes, like we talked about in the last workshop, they don't necessarily want you to do anything unethical. They just want the answer that they want so that they can win the case. But it could be that they are trying to get you to slip up so that you look as though you're unethical. We've talked about that, not making any kind of assumptions about the like an alleged perpetrator if you've not evaluated him or her or them. Meeting with someone who's been accused or an alleged perpetrator does not count as an evaluation. So just because I have a parent that I've worked with, let's say a child makes a disclosure of abuse and the parent comes in and wants to talk to me, because the parent does have that right. And then I go to court and I say, oh, the child disclosed this. And yes, I think that he did this because I met with him and da-da-da. I'm not evaluating this person. So I can't give any kind of information about the other, whether it's a perpetrator or the other parent. I can't give any kind of diagnosis. I can't give any kind of any really kind of, I can talk about what they have said. I met with this parent, and that parent expressed concern about this. The parent denies these allegations and was concerned about where the allegations may come from. I can say that, but I'm not going to give any opinion on whether or not I think what he or she or the person said is true or not true. Does that make sense? You want to be familiar with attorney's language. Isn't it possible that, would you agree that, so they, you want to answer the questions, only the questions that are being asked. Isn't it possible that this child could be having these behavioral problems because of the conflict that exists between these two parents? Yes, that's possible. I mean, really anything is possible, right? So, yes, that's possible. So you would agree that, no, I wouldn't agree with that. I would say it's possible. And so, like in that case that I mentioned earlier, isn't it possible that this harm is being come from the mother and her influence on the child? That is possible. So you'd agree that the father should have custody then to get her away from this child. No, I didn't know. I wouldn't agree with that. It said it's possible. So just know that language. Be careful with the would you agrees, like I said, because it reminds me when in college, when you take that speech class and you have to write a persuasive, I can't say that, that you get them to agree to the first thing. Would you agree that the sky is blue? Yes. Would you agree that the sky is beautiful? Yes. Then you would agree that you want to pay $5,000 to a trip to Mexico to see the big beautiful blue sky. And it's like, well, wait, I didn't say that, but they get you to say yes, 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 yes. I had a case where the attorney the mother was drinking a lot with her friends in front of the children. Would you agree that it's problematic if a parent is drinking to the point of intoxication in front of their children? Yes, I would agree to that. So you would agree to, that it's not appropriate to do X and Y and Z. Yes, I would agree to that. So then you agree that this mother should not have custody in the better place. No, I didn't know. I would agree that is problematic. So just be careful with those types of statements. And what if? Well, what if? Those questions make me nervous because again, I still go back to, well, I mean, if that happened, that's a possibility, but that's a hypothetical situation. So it's very difficult for me to answer hypothetical questions due to the nature of this case. Biggest thing that is just, and I've seen it with supervisees where and new professionals, attorneys, and they've done it to me. I just don't fall into the trap where, let's say you're working with a case where they're, let's say it's high conflict divorce, or let's say it's abuse, whatever, that one attorney usually likes what you have to say more so than the other attorney. But some attorneys do their homework better than the other attorneys. Some are more prepared. I've seen attorneys who have come up to me. I've had supervisees that have done it where they've gone up to them and said, hey, what do you think I should ask you in court? Do not answer that question, because that makes you biased, that you're siding with one person. You're going to keep your testimony very neutral, very basic, and you're not going to show bias in either way. So if you get that question, I can't answer that question. I'm not an attorney, that you have to do the research and decide what you want to ask me. And just be cautious about that. I see that asked a lot. And if on the flip side is that if you do answer that, well, I think you should ask me this, and I think you should ask me that, and I think you should ask me this, then the other attorney can question you about, have you had conversations with this attorney? What did you talk about? What did you share with them? And so it really, really disrupts your credibility if you do that. Ask for questions or for clarification when questions are confusing. You can say, I don't know. You can refer to your notes, but just know if you bring notes, the attorneys can ask to see those notes and it can become part of the court record. So what I will do is just write down numbers. So how many times have I seen the child? I know that this number is 17 and this number's 4, and so it's almost written in code. So even if they ask to see it, they can have it. And what is that? It's just a bunch of numbers. Well, why do you have numbers? And like, well, just to, it's my system of remembering details about the case. And that's all I'll say. You're going to respond as objectively and definitively as possible. Make eye contact. When the question's asked, you're going to make eye contact with the person asking you the question. When you are giving the answer, you're going to look at the person that you want to convince. So if you're in criminal court, you're going to look at the jury. Now, for those of you who have seen that Johnny Depp Amber Heard case, and her looking at the jury was annoying, and the jurors found it awkward, that's too much of that. But if I'm answering the question, I may glance at the jury from time to time, or if I'm giving where the child gave a disclosure and I want powerful, this is really powerful what this child said, then I may say, she looked at me and said her father hurt her. So I'll give some statements for power, but that's where you're going to direct. Now, if it's just a chancery court, a divorce court, I'm just going to respond back to the person. Sometimes I will look at the judge though as well. If there's something again like that I really for impact, I might look and look at the judge and answer. Again, avoid appearance of bias. You want to be calm, polite, and professional, confident, and self-assured. Don't feel intimidated when your credentials are attacked. They will attack your credentials. They still attack mine. I've been doing this for 26 years or more. That's what they're there to do. Don't take personally any challenges to your testimony. I had a case one time where one of the attorneys, the two attorneys were arguing, and I could hear them like arguing. It was over how they were going to pay my fees, because they were saying, well, you subpoenaed her, you should pay it, and you should pay it. And that one attorney looked at him and said, we're not paying for your whore. And I was like, and the attorney came up, it's okay, it's just a legal term. It's just a legal term. It's a legal term. And I was like, I don't know about y'all, but I don't like being called a whore by anybody. But I'm not going to take that personally. It's called a whore of the court. And it just basically means a hired gun. But you can't get offended by that type of language. Use your own your own words, not the attorney's comments. I'm an attorney's word. So like if they said, so do you think it's appropriate for a parent to be drunk in front of their child? I would say it's problematic if a parent is drinking to the point of intoxication around their child. So I'm not going to use their language. The difference in depositions and testifying in court is depositions, they can ask you anything. You know, have you ever been, seriously, they've asked, have you ever been to this attorney's house? Have you ever had lunch with this person? Have you, like, they can ask you anything that they want to ask you. I was on a child abuse task force that in my area, they asked me to be a part of it. And they were trying to insinuate that I was profiting from the task force because they were referring to me. So you do get referrals from the task force, and but they can ask you anything that you want. I think my longest deposition was 6 hours. 6 hours. I'm sitting there answering questions. And so you're really going to want to know the details of the case. But just in knowing that they can ask you anything, just be prepared, but also keep your composure. Don't let that rattle you. Most importantly, before testifying in court, because they do the deposition, ask you all of these questions, and then they sift through it to find what they think is most important to ask you in court. Because in court, they may only have 2 hours to try their part of the case. So it's a 4-hour hearing, they get 2 hours. So they're going to sift through that to find the most important material that they want. What you want to do is request a copy of your deposition and review it before giving testimony. That is the most important thing that you can do, because it may be 8 months that goes by before you go to court. It may be a year since you gave the deposition. And because they're asking you so many questions, you might not remember how you answered that question, or you might not remember what questions they even asked you. So it's always very helpful for me to get my deposition, read it, and I'm like, oh yeah, I forgot they asked me that. They're definitely going to ask me that in court. So it helps me be more prepared with that. So my last helpful tip for you all is to ask an attorney if you have questions. You know, I mentioned last time having an attorney on speed dial. You know, have somebody that you can call and pick their brain if you have questions, you know, about court process or testimony. Take a deep breath and breathe and consult, you know, have colleagues that you can consult, and that also means with your supervisor as well. So best of luck with that, with court involvement. And we've got a few minutes left, or maybe 1 minute left, but I don't mind staying on if anyone has questions.
Thank you so incredibly much. This was beyond interesting to me. What we can do is put an email address in the chat, and then anyone who has a question can send those questions to me, and then I can send them to you, Dr. Moore. We can just stick them in the area where the Trust the Process recording is, because I actually have 9 questions that I've written down. So when you come back from term off, you can take a look at those questions and post them if you like. And if anyone is interested in sending a question to me, I can put my email address in the chat.
Well, and Dr. Rush Wilson, I'll be glad to actually do a Zoom recording and record the answers to that question. That way, if I need, you know, want to elaborate on that,
Sure.
I'd be glad to do that. And then we can post it with the other. Yeah.
We can post them all together. That way we don't have to run people too much over time, but can make sure that all of that information is disseminated to all of you. So please take my email address, send me any questions you have for Dr. Moore. I'll get those to her, and then we can follow up with you and post that in the discussion area where Trust the Process is housed.
All right. Thank you all for attending today.
Thank you. So thank you, Dr. Moore. I can't wait to actually have you answer these questions.
I can't wait. I love
Denise.
Just a second. Yeah, I would like to, I had some observations, but I'm not going to take your time with that. I'll send them to Dr. Rush Wilson, but I just wanted to thank you again, for this amazing opportunity. It's absolutely priceless.
Thank you.
Priceless. And where can I find these recordings to rewatch it?
Okay, so Denise, I will actually send the link, well, how to find them directly to you, but I will tell everyone in the advising area, there is an area called community involvement. And in there, you can find everything from all of the student groups to Trust the Process and other things too. So all of the Trust the Process recordings for the last couple of years are housed in that area. So you can read what they're about, see the recording, watch it as many times as you like.
Okay, great.
Yep, and I'm going to send that to you directly. I'm going to post this one as soon as it loads, and then we'll go from there.
Okay.
Thank you for spending part of your
Thanks, Sarah.
Saturday morning too with us.
Thank you. Enjoy your free time, doctor.
Yes,
Oh, thank
it's
you.
very
Thank you.
If there's
Thank you.
such a thing, if there's such a thing.
I know, right? Right.
Really.
Thank you. Have a great weekend.
Thank you.
Y'all too.
Bye-bye.
Bye-bye.
It's so good to see you.
Yeah, it's good to see you. Thanks for the reminder.
Oh, that's okay. Because I didn't know how many people actually saw it. None of the CES classes got the reminder. So I
the
posted,
recording,
yeah.
the recording is still on.
I'm gonna stop it too. But I
Yeah.
posted those to them this morning just in case, so that